Next item on the agenda is House Bill 5005, or excuse me, 4005. Before we get going, we're going to have 20 minutes against, 20 minutes for, and then council will answer questions and things like that. If we do not get finished by the time for the floor session, we will recess until 7 p.m. this evening. It's the best time that I've been able to come up with for us to come back in and deal with that. So council will explain the bill in lieu of having it read.
Thank you, Mr. Chairman, members of the committee. House Bill 4005 repeals Article 5A of Chapter 21, which mandates a prevailing hourly wage rates be paid by public authorities for the construction of public improvement projects costing over $500,000. Under the current law, Workforce West Virginia, in coordination with the WVU Bureau of Business and Economic Research and the Center for Business and Economic Research at Marshall University, are tasked to determine the methodology for annually calculating the prevailing wage rates in the regions of the state. The determination is to be evidenced by all appropriate economic data, including the average rate of wages published by the U.S. Bureau of Labor Statistics and the actual rate of wages paid in the regions of the state. Workforce, in coordination with these university economic groups, are to determine the hourly wage rates annually on January 1st. The article also requires these rates be included in any bid request and incorporated into any contract for the construction of a public improvement project exceeding $500,000 in cost. And the article also provides for rulemaking authority and other provisions related to effectuating the mandated wage rates. And Mr. Chairman, the bill is single referenced here in the Senate to this Committee on Government Organization.
Okay. Thank you, Council. And we're going to forego questions to councils now. It's time for Steve.
Thank you, Mr. Chairman. Steve White, Director of the Affiliated Construction Trades, and I will be speaking along with 4 others, so 5 speakers, 4 minutes, trying to keep with your schedule and help me stay on my 4 minutes, if you would, please. So we are speaking against repeal, and the part that I'm going to take, just 2 parts, 2 minutes each, perhaps. One is no savings. We don't believe there's savings. I'll talk about that, and I want to talk about the study that Workforce underwent. We feel we have excellent data, would love to share and talk. We've tried about will there be savings. We had data last year, a study of thousands of projects, school projects, that showed that when you look at states without prevailing wage surrounding us, even to North Carolina, that there were no savings. The rate per square foot is the key to look at. Rate per square foot, we were doing schools and have done schools cheaper. So why are we doing it? The premise was savings. We don't believe there'll be savings. That was further evidenced by the short window of 3 months where there was no prevailing wage. Some people will tell you there's savings. We've got the data to prove there was no savings. That is, you have to adjust for site costs. There was a lot of discussion during the interims about this. When you adjust for site costs, one of our speakers will elaborate, there was no savings. There were reduction of wages. That's a fact. That will happen. But the taxpayers will not save money. We don't think, for those reasons, repeal is a good idea. We think it's a bad idea for the workers that I represent and their families, for the contractors we partner with, that we feel will lose jobs. Now let me switch to number 2, the methodology. While we understand people are unhappy with the methodology, we think the methodology could be improved ourselves. I think we should look at the facts and the data that was collected. Workforce did a good job in the short period of time. Hundreds of contractors gave data. They sampled thousands. They did oversample. Too many contractors led to some misunderstanding. Hundreds of contractors, much better data than the BLS data, much better data than the data that had been submitted past. This is good data about what's the market rate. Some people have said, well, it's just the same thing as before. It is not the same thing as before. If you look at the data, you will see. Some areas, more than almost 60%, 58% saw a reduction of wages. Some because of the way they do the math, and other because that's just what the survey showed. Some areas, $16.74 for our electrician, senator, in your area decline. So to say it's the same thing is not looking at the data. To say that it's reflective of the market, I think, it could be improved. Of course it could be improved. More data, love to get more data. Better explanation about how much was prevailing wage data. We think it was very little. I've heard people think that it's a lot. That's excellent conversation topic. So with that, I feel like I must be close to my 4 minutes, Mr. Chairman.
You're at 3 minutes and 10 seconds.
Okay. Summary, no savings. Others will tell you there's savings. We can show you that there were not savings. The methodology, while not perfect, could be better, was what it set out to do. 20% of that data is BLS data. It also said, as I heard the lawyer remark, that you're to look at actual wages. It looked at actual wages. We've got actual wages. We've got good data. I would urge to try to find a way to get better data. And with that, I thank you very much.
I'll hold my finger up when you've got 1 minute left, and that'll help the
Thank you.
process.
Thank you, Mr. Chairman, committee members. My name is Glenn Jeffries. I'm the president of Cornerstone Interiors, which is located in Putnam County. Our company was established in 1996. 1 year ago, we were here discussing prevailing wages, and now here we are again. The question that I ask myself is why? During the last session, everybody came together, worked hard to come up with a compromise. We raised the threshold to $500,000, the highest in the country. Workforce West Virginia was given the task to come up with a new methodology, which has only been in place for 4 months. But for some reason, we do not want to give this new methodology a chance. Now we want to completely remove it. What I'd like to do is show why contractors and myself believe a prevailing wage is important. If we go back to last summer when there was no prevailing wages for 3 months, Senate Counsel was asked to look at 4 projects: Sarita, Canova, and Wayne, Suncrest in Monongalia County, Cedar Creek and Gilmer, Yeager, Panther, and McDowell. The information that was presented during those interims was that there was cost savings of more than $2 million on 2 projects that were not paying prevailing wages versus the 2 that were. As a contractor, I've had 20 years experience, 39 years of experience in the construction industry here in West Virginia. I found this odd. So I gathered all the information and spent some time looking to come up with the correct cost. Now, to get a true cost, you need to eliminate certain items of the bid. Site work is one, FF&E and cost is another. I also found out that out of the 4 schools, Yeager Panther was an outlier to use for comparison purposes. That project required masonry construction and had a different foundation system because of the site. But the 3 other projects were performed with similar type construction. When I compared Sarita, Canova, Suncrest, which did not pay prevailing wages, with Cedar Creek, which did, the difference in square foot cost amounted to $2.15 a square foot. Here's the interesting part, that one contractor received the bid for 2 schools. One paid prevailing wages, which was Cedar Creek, and one did not, which was Suncrest. Now remember, there was only a couple dollars square foot difference in those schools. My question is to you, where was the savings? There was none. Here's the disappointing part. The construction workers on Suncrest, on certain projects, saw their wage cuts 35%. This is a big concern for me and more than 600 West Virginia business owners in this industry. it will bring tremendous uncertainty with the construction worker participation in this field. Over the past year, myself and other contractors have built a workforce of local tax-paying men and women which we can count on. They show up on time for work, they are well-trained, they are drug-free, ready to give a hard day for a fair wage and benefits. Let me finish with this. I am asking that we work together with the individuals who represent this industry and find a fair answer that is good for the West Virginia taxpayer, the West Virginia contractor, and the West Virginia construction worker. We need to keep a prevailing wage here in West Virginia. Thank you very much, Mr. Chairman.
Thank you.
Good morning. Good morning, and thank you, Mr. Chairman and committee members, for the opportunity to speak and give one person's perspective on West Virginia and the issue of prevailing wage.
State your name, please.
I'm getting ready to do that, sir.
All
My name's
counsel.
Mike Davis. I'm Vice President and General Manager of G&G Builders. We're located in Scott Depot. We've been in business, this is our 40th year. I'm a lifelong West Virginian, as I'm sure most of you are, and I've seen good times and I've seen some of the worst times that I'm sure that you folks have lived through also. As the seats of power changed in the last election, I hoped for a better future for my family and my neighbors. How surprised I was to find out that with all the real problems that West Virginia has, it was decided that prevailing wage was the worst. It was the first item that needed to be took up. You decided the path of prosperity, in my opinion, was to lower wages. As I said earlier, this is one person's perspective, and this is my perspective. Business Insider ranked West Virginia 51st in the nation in terms of a bad economy. This didn't happen overnight. WKTV reported that West Virginia ranks 46th in the poorest in the nation in education of our children. 76% of our 8th graders are below proficiency in math. I ask you how prevailing wage affects that. Gallup poll rated West Virginia 50th in the nation in the well-being of its citizens. American Health rated West Virginia 47th in poorest overall health. WTAE in Pittsburgh reported that West Virginia has the highest drug overdose rate in the nation. 34 out of every 100,000 people are affected by drug overdose. So bad that President Obama made a rare visit to West Virginia to tell us that West Virginians are killing themselves at an alarming rate. Where is prevailing wage in that? The list goes on. West Virginia's lost the war on coal. Thousands of coal miners, support personnel, truck drivers, restaurant staffs, and others sit at home this very morning with no hope of employment. Private development in most regions of the state is practically non-existent, has nothing to do with prevailing wage. Other states such as New York, Michigan, Texas are running national television ads and campaigns driving their economic engines. Where are we in that picture? What effect are we making on a national level? In closing, we can all agree that change must come to West Virginia, but lowering wages on one specific group of people does not help all the people. It's my perspective that it hurts all people. I ask you to help working people and help West Virginia.
Good morning, Chairman, Committee. Thank you for the opportunity. My name's Keith Hughes. I'm a resident of Marshall County in Northern Panhandle. I work for a contractor, Jarvis, Downing and Emsch. We are a general contractor, hire many trades, many crafts. We have roots there from the 1920s. We do prevailing wage work, we do commercial, we do bid work. One issue I would like to talk to you about today is the effect that the elimination of prevailing wage would have on the number of people in our state that have health insurance. All of our people are involved in a health plan of some type. Those dollars are returned to the medical community in West Virginia. Sure, some of them are prevailing wage dollars, some are from commercial dollars from other jobs. But these funds return many dollars to the hospital system. I believe you all have a spreadsheet that was presented, and it shows data from some different crafts and organizations, contractors in West Virginia, and it lists 17 hospitals. Most everybody has one of those hospitals in their area. You can see that there's over $40 million spent at the hospitals. That is not prescription drugs, we'll touch on that in a minute, or anything else. That's just billed from the hospital. So if you look at nationwide statistics, like from CMS, a fund, if they spend $40 million, that's 30%. That's an average. That's been the average for 5 to 10 years. That's 30% of their money spent at a hospital. Another 30% could be spent, or I'm sorry, 20% could be spent at urgent cares, doctor's offices, family practitioners, things of that nature, outside services. So that means you're looking at $28 million. 10% of healthcare fund is spent at a prescription drug facility or mail-in forms. That's $12 million. So you're looking at in the neighborhood of $80 million that is returned to the medical community in West Virginia. Now, guaranteed, that's not all prevailing wage dollars, but there's a huge amount in there that is. So with the elimination, those funds are going to decrease. That amount of money is going to go away. You know, maybe 25% the first year, maybe 30%, but it's going to diminish over time even more. So most of us know someone who's involved in the healthcare field. My daughter, you know, somebody's spouse, a relative, a neighbor. That's dollars that are spent to employ people like this. Nurses, radiologists, receptionists, everybody at a hospital in the medical community. So when this goes away, where do these people get their health care insurance? Where do they get their health care? Somebody has to fund that. So with the elimination of prevailing wage and some of these people losing health insurance, the burden may become even more on the state of West Virginia providing insurance for these folks. So that is the issue I think that has not garnered much discussion or been looked at. It's a tertiary issue, but it's one that's very important. And if you have any questions, I'd love to discuss that spreadsheet with any of you. But thank you for your time.
Mr. Chairman, members of the committee, I'm Mike Clauser. I'm with the Contractors Association of West Virginia. Our membership represents about 450 members statewide involved in the building of our schools, highways, water, sewer, hospitals, and other infrastructure of the state. Last year, we came before members of this committee and said that some of our membership were in total favor of total repeal. We had a few of our members who were in supportive of the status quo in keeping prevailing wage as it currently was constituted. But we also said that 100% of our membership was committed to coming up with a new methodology to determine a true prevailing wage in the state. And Mr. Chairman, thanks to your leadership and the leadership of the Senate, we were able to come up with a new methodology that maintained prevailing wage and look at a new way to calculate rates statewide. We were encouraged when we saw the results of the survey in which thousands of contractors throughout the state responded, large, small, all geographical regions of the state, contractors that did private work and also public work. We also shared, I think, a lot of concerns, as have been indicated by this committee, that when the final methodology was developed, there were a number of questions. We had a number of questions on what the final methodology was. So we are here today to basically tell you that our position, we would like to continue as what we discussed last year. We would like to see a prevailing wage determined, but we would like to see something that gets us to what all of us would consider a true prevailing wage statewide. Thank you.
Steve, there's still 2 minutes.
We're done, thank you, Mr. Chairman.
Okay. Next.
Thank you, Mr. Chairman. Members of the committee, my name is Brian Hoylman. I'm the president of the Associated Builders and Contractors of West Virginia. We represent both large and small-scale commercial construction companies here in the Mountain State. Our organization and its membership strongly supports the repeal of the state's prevailing wage law. It is our position that this law unfairly charges the state more than necessary to complete its duty to the taxpayers. Not only does this law prohibit competition on state-funded projects, it gives a direct advantage to certain companies and third-party organizations over their industry counterparts. This law has foregone its intended purpose and meaning to establish a true prevailing wage and is now a government mandate to ensure those who choose to charge the most for construction are not underbid by their competition when and only when the state or one of its political subdivisions are paying for it. I'd like to expand on this a little more to provide some clarity due to the fact that many who oppose this legislation claim the law will cut wages, diminish quality and safety, and bring rise to an out-of-state workforce to take the jobs of our workers here. I've been asked, how will this save the state money if it does not cut wages? The answer to that, the primary reason for that, would be by introducing competition in a largely inflated fringe benefit package. Non-union construction companies, which comprise the bulk of ABC's membership, do not have financial obligations to organize labor unions. They negotiate wage and benefit packages with their employees on an individual basis, and nowhere in that package are costs associated with collective bargaining agreements. Under the current prevailing wage law, the fringe benefit package includes the costs for union operations, overhead, or training. Therefore, when the state lets a project for bid, non-union companies are required to include that cost in their bid packages, even though they have no union operations to fund. Without a mandate in place, they can be largely more competitive on costs with regards to fringe benefits, and I'll give you an example. Under the newly recalculated prevailing wage law, a plumber pipe fitter, on average among all 7 regions, is required to be paid by taxpayers about $55 an hour for work on public projects, regardless of the size or scale of that project. Of that $55, about $34 of that is the worker's base wage rate. This is what they pay taxes out of. Him or her will take home with them at the end of the day. The other $21 goes into their fringe benefit package. And now to put this into perspective, if you annualize that, that equals $42,000 a year that taxpayers are required to pay in benefits alone for that one worker. Now keep in mind the average income of all West Virginians is $23,000, not their average benefits, their average income. Now of that $42,000 that plumber and pipe fitter receives in benefits, only about half of it actually goes to the workers' benefits, their health care plan, usually a defined benefit plan, or their health care, paid time off, et cetera. The rest of that money for a union worker would go to a number of other things, or training or safety or otherwise. Non-union construction companies are prohibited from using this additional fringe dollars allocated on public projects for anything other than that worker's benefits directly. Therefore, if there's no mandate in place, they can provide the same competitive benefit package for about half the cost to the taxpayers. According to the Bureau of Labor Statistics, and even union representatives here in West Virginia have acknowledged this, the base wage rates in prevailing wage states compared to non-prevailing wage states do not differ much. The largest difference that you see is the cost of the fringe benefits that are required to be paid either through collective bargaining agreements or state prevailing wage laws. Some of this additional money mandated, like I said, does go to safety and training programs. However, unions have significantly more flexibility when it comes to how they're allowed to utilize these funds. I've seen actual fringe benefit packages that have money earmarked for things such as industry promotion, political action committees, or sometimes they're just marked as other. Since they're not subject to the same ERISA laws as private employers, they're not required to allocate these funds directly on that employee's behalf. Non-union companies, despite investing millions of dollars in the state every year in West Virginia, on their quality and safety training programs must pay for them out of their overhead or their profit margins, and they're not allowed to fund them out of their fringe benefit packages. The primary difference here when it comes to funding our company's efforts with regards to training, overhead expenses, representation, or even our political efforts is that those efforts are not subsidized by the taxpayers. Our companies must invest in these programs or external endeavors separately. This aspect alone defies the notion that prevailing wage creates a level playing field when in fact it's quite the opposite. Now, our organization has never questioned the quality of work or dedication to safety provided by labor unions or union companies, and will continue to respect those dedication to those efforts. However, our member companies live under a continued stigma that we, not created by all, but by some, that our workers and our companies are not capable of providing quality work, they do not care about safety, they do not adhere to drug-free policies, and they don't deserve to work in West Virginia simply due to their labor affiliation. While I will not respond to those claims directly about the majority of the state's workforce, I will say that our member companies have been providing both the private industry and the state's taxpayers with safe and quality construction for generations in West Virginia. ABC member companies have built billions of dollars worth of highways, schools, hospitals, university buildings, utility infrastructure, countless other projects for the state of West Virginia, and will continue to do so with the same dedication that it always has. I've also been told that during the temporary repeal of the state's prevailing wage laws in the summer of 2015 that the state did not save any money on public projects. This was actually proclaimed on public radio the very day the new wage rates went into place, long before you can actually do a thorough analysis of what happened. This is something that our organization and others took the time to do. We looked at dozens of projects let for bid during the temporary repeal and fortunately had the ability to analyze elementary school construction costs due to the fact that 2 brand new schools were let for bid during that time, along with 2 major renovations. I know this information has been expressed to you all before. I know it's been disputed as well, but I want to clarify that our analysis put every project that was focused on under the exact same criteria, with no exceptions. What we found when we compared 2 elementary schools that were let for bid in the year prior to the 2 elementary schools that were bid during the temporary repeal was a difference in cost of $34 per square foot. Or if you apply those to the actual savings, about $2 million on each project. Since we anticipated a dispute on our research, even though we compared the final average of the square foot cost of the 2 that were done during the temporary repeal of $190, we compared that to a Union Commission study that was released in 2015 to this body that said that elementary school construction costs in West Virginia were $209 a square foot. See, when you compare those 2 numbers, it was still about $20 lower on average per square foot when you use their analysis and not ours. Despite what's being said, we removed all the site work, all the soft costs, all the contingencies from each project and focused solely on building construction. The difference between our research and the research disputing our findings is that according to them, and this is what they said, they went back and selectively removed various portions of the project they claim were unnecessary. The Iagar Panther Elementary School was completely removed from their research. One of the primary reasons, I know a few more were mentioned, but one of the primary reasons was because there was an advanced water treatment facility that was added to this bid. But since it was one of our contractors who built the school, we went back and looked at that data, and that particular project cost about $103,000 additionally, or $2.29 reduction in square foot cost if you were to remove it. So all in all, this marginal square foot cost, along with a few other things, were enough to completely remove that from their analysis, but it still fell under 2014 prevailing wage rates. It was building construction in the state of West Virginia that required prevailing wage. The fact that it was expensive is not enough to remove it from that research. To that end, every project has something in it that wasn't in the project before it, and it's not going to be in the project after it. That's guaranteed with the complexities of our industry. If it went into the actual cost of the building construction, it was included in our analysis. At no point were we selective in what we decided to use to enhance what was the outcome of our cost. I want to mention an Ohio study who repealed prevailing wage in school construction alone in the early 2000s. Their study was commissioned following the law's passage by the nonpartisan research and accounting arm of their state legislature, similar to our post-audit division, that found that in the year following the law's implementation, Ohio saved $490 million on school construction projects. Most importantly, the study found that there was no overall loss to quality or safety on these projects in the absence of the mandate. In continuing to analyze school projects here, we also noticed one other thing, that out of those 4 major projects let during the temporary repeal, not a single one of them went to an out-of-state bidder. All 4 of those projects, the 2 renovations to schools and the 2 school builds, were let in border counties and they were all received out-of-state competition, out-of-state companies that bid on them. Suncrest Elementary School, which was bid under temporary repeal, received a total of 4 single prime bids. 3 of them were from out-of-state contractors. But again, it was awarded to the low bidder, which was a West Virginia contractor. Interestingly enough, one of those state companies that was not low on Suncrest was the low bidder on a school construction job in Lewis County the year prior when prevailing wage was in place. We cannot find any research, any data in West Virginia or otherwise that concludes the absence of a prevailing wage law gives out-of-state contractors an advantage over in-state companies, or that the presence of one gives in-state contractors an advantage over out-of-state companies. While it may sound likely that without a prevailing wage in place, anyone and everyone with a hammer in their hand or a bus full of workers with any level of expertise or from anywhere else can bid on a project for dirt cheap, but that simply isn't the case. We have stressed this point constantly, and we will continue to, that your company and your workers must meet a series of qualification guidelines in order to even consider bidding on a state-funded project in West Virginia. Repealing the mandate would not repeal the law that requires workers and foremen to have OSHA 10 and 30-hour training before they enter a job site. It would not repeal the requirement for companies who perform state work to be bonded by the taxpayers to protect their investment. It would not repeal the inspection guidelines construction companies must undergo when building these projects. It would not give illegal migrant workers a legal status, and it would not remove the responsibility of the Division of Labor for enforcing those laws. Certain job classifications, such as electricians, even require individual licensure to work on any state-funded project in West Virginia. Therefore, if you're an out-of-state company looking to bid doing electrical work in West Virginia, each and every one of those workers must take the electrical licensing exam here, which West Virginia is only one of a few states that do that, especially for certain specific trades. This law, along with the countless others, would ensure the quality work and safe workplaces, and they wouldn't be repealed with the passage of House Bill 4005. In conclusion, I want to reiterate the fact that this law, throughout its history, has gone well away from what it was intended to do. We are forcing companies to pay more than is necessary for them to complete their jobs asked of them by the taxpayers, all because third-party organizations who have a significantly financially invested interests in this have manipulated a law that guarantees they cannot be underbid by their competition. For that reason, we are unnecessarily limiting our already strained state resources and the ability to invest in new projects in nearly every level of state government. That's all the remarks I have, but if you have any questions or anything, I'd be happy to answer.
Okay. For the sake of record, your time come in under 12 minutes. The other ones were 18 minutes. There's nobody else to present?
Just me.
Okay. So now, it's time for questions from the members, discussion. Punch in if you've got questions, and what I'm going to do is let you ask either counsel or pro or against, and have them come back to the podium, ask the questions that you choose to do. So, discussion. Questions? Okay. Got it.
Okay, thank you, Mr. Chairman. I have a question to ask the chair, just a point of order. This is probably one of those issues that we will struggle with again. We're already struggling with. How can that not be important, first of all, for the Finance Committee to consider this, which is has very important fiscal impact to the state? And secondly, where is the fiscal note on this? There has to be a fiscal note in this as it affects who we are. And I guess third, and I probably know what answer I'm going to get on the third one, is we had a rule passed that does not affect legislation, but there's to be a job impacts report. And there's not a job impact. I asked that question last year. Where's the job impacts study that we requested that's to be on these pieces of legislation? And I don't see this anywhere. I know that's I guess at the decision of the president. But should there not be a job impact statement with this? Those are the three questions I have for the chair, I suppose.
I'm not going to say much other than the fact that my understanding is that these same questions was asked in the House and the determinations were made that they were not necessary. In fact, when it comes to the fiscal note on it, that this applies to things other than state government, and if there's savings on it, then fiscal notes are not necessary, is my understanding. Your first question, repeat that for me because I lost it.
And my first question basically is why, if this is such a serious issue, why are we limited this to one committee? Why not let finance also look at this? Because it does affect the finances of the state.
Again, I don't make that determination, but I can actually give my perspective on that, and that is this is such an important issue that what it is that rather than go to finance, it goes to the Senate floor where it's committee. It's not a committee of the whole, but it just seems be appeared that way. That way, each and every member of the Senate has the opportunity to weigh in and share their perspectives on it. So,
Well, and
further questions?
thank you, Mr. Chair. I may disagree with that. I will have some questions of the attorney later, but I had those the chair right
You're
now.
welcome to do that right now.
Well, there are a lot of questions I have about, well, I'll do that in a little bit. I want to think about that. I want to think what you answered too.
Okay. Senator from Taylor.
Thank you, Mr. Chairman. With regard to the fiscal note, we've had testimony here this morning from both sides that implied that wages were likely going to go down if this bill passes, and in fact went down based on the compromise bill that we passed last year. And I'm a little confused. If wages go down, then our state income tax is going to go down. There's no question about that. And I'm a little confused with your response and the response from the House as well as to this bill has no fiscal impact, so we don't need a fiscal note on it. I think we absolutely do need a fiscal note on this bill, and I think the chairman should lay this bill over until we have a chance to recover, to receive one from the governor's office or whoever it is should be out there. There's no question it's going to have an impact on the state resources, and we need to know how much that's going to be before we move forward on this. Thank you, Mr. Chairman.
Okay. First of all, the opposing side has claimed that the wages will not go down, but I guess I need to back up for a second. Did you just make a motion?
Not yet.
Okay.
I asked a question of the chair as
Wow.
to why we, with regard to your answer, that we don't need a fiscal note.
I think I've addressed that already onto that, and I don't see how I can do much better from that standpoint. You've arguments on both sides of it on this, and it is not before us. The House ran it without it. The argument was made over there as well. It is not second reference to finance. That would indicate that there would be a need for a fiscal note at that point in time. And the chair does not make that determination on that. Now, if you'd like to make a motion to lay it over, I'm happy to entertain that motion.
Thank you, Mr. Chairman.
Or you come, you're not lit up. Senator from Jefferson, even though you're here, you got your.
I'm still not on. Oh, yes, I am.
Yeah, you're.
I believe the second speaker after Steve White spoke to this, so I really throw this out there for the committee and possibly someone else to speak to. All the senators that are on this committee were here last year, I believe, and as members of the Senate. We only have 2 new senators that weren't here, but they're not on this committee. And we talked about the work, and the chairman was deeply involved in that, of the attempt to find a compromise. And I've often said in my 26 years of public service that compromise politics is the art of compromise. And there was a lot of time and a lot of effort spent on that, as the chairman remembers, last year. And what we came up with was to have an independent body. Now, the bill last year took the Department of Labor out of this. They're not calculating it anymore. So that was a major change. I assume that many thought, and I talked to members last year, that the Department of Labor somehow was skewing this. So we took it out of their hands and put it in workforce development. And then the second, that was a major change. And the second step was to have an independent body do the calculations, collect the data, decide what needed to be used, and work on a true prevailing wage. And that happened. Now, I'll caveat that it happened the first time, and certainly things can get better in something this complicated over the second try and in subsequent tries that, as Mr. Klauser said, they still have some questions about the parameters used, and I have a few questions, and I'm sure everyone does, but that doesn't mean you throw the baby out with the bathwater. West Virginia University, and I heard during the Right to Work bill, is touted as the flagship University of West Virginia, and it is. There's no question about that. We're all very proud of WVU and especially the ball team. But at the same time, now we're saying that we're in the report from WVU that was hailed that was used to support the previous bill on right to work. Now we think that WVU didn't do a good job in their handling of this. And I think that's troubling to me, to use that flagship university in one instance and then throw the baby out with the bathwater in another instance. And I think we should ponder that question. Maybe it's because other factors outside the report are driving this. But as Mr. Klauser said, from the Contractors Association, and I think his organization, I listened to them specifically because they have both union and non-union contractors. They're divided on this, as Mr. Klauser said. So I look to his comments to not be to one side or the other, but right dead center. And they questioned and still say they have questions about the methodology. And I think that's where this legislature should focus in looking at the trial run and seeing what the university used. This all happened very quickly for the first time, and let everyone look at the methodology and open it back up. I would assume because the total repeals here, this is not a refinement of the methodology that WVU used, which I think would be the appropriate thing for us to do in this legislature, short of a total repeal. But again, I let the other members think, ponder this, that there is another analytical way to do this by looking at what we created last year and the recommendation of our flagship university, and literally not throw the baby out with the bathwater. Thank you, Mr. Chairman.
Another member? Seeing no members, and this is not, I'm not lighting up. Oh, okay. Senator from Greenbrier, you weren't coming on.
Thank you, Mr. Chairman. I'm often pretty dim-witted, but this says that I am dim-lit today because I have no light at all on my mic. To our attorney, James, and I don't see, there he is. I couldn't. James, I've been here so long this session, I almost forgot your name. I was going to call you Don, so just forgive me. I don't want to go and extend this out a long period, but what's the purpose? Why did we have prevailing wage to begin? What's the reason why we had prevailing wage?
I mean, I couldn't speak to the policy behind.
No, I don't want
enactment
the
of
policy, but why was it put in place to begin with? What was the reason, the history of it? You know?
No, I can't speak to that.
Okay, and that's fine. I guess one of the comments I hear oftentimes that it hurts free market. In what ways, and again, this may be a policy, but in what ways does it hurt free market? Is that a policy answer?
Yeah, I believe any way I answer that would be policy.
All right. Well, we could talk about Davis Bacon, but we won't do that. That's all. I think it's important to look at the history of this, but that's fine. That's fine. Thank you.
Senator from Brooke.
Thank you, Mr. Chairman. My question is for Mr. Klauser. Thank you for being here, Mr. Klauser.
Yes, sir.
I noticed you may have been the only one that spoke of the methodology of prevailing wage. Some of the members of this committee were prevented, eliminated, or were not invited to attend any of the meetings with the programs and the meetings that occurred, the research over the last summer months, getting to this point. So I have never seen anything except what's in the papers about the methodology. Could you make a brief explanation of your concerns there, of what went on, what transpired? Because I'm unaware. I don't know what occurred. We just weren't permitted. We were excluded from all of the meetings, and I'd like to know what occurred.
Well, we were excluded as well, Senator, so I cannot speak to what transpired to come up with a final product. I was in a meeting with very early on after the bill was passed. That was just kind of a organizational meeting where a lot of people were invited. I was invited to that meeting. Basically, that was to say that the process was going to start. Workforce West Virginia was going to be coming up with recommendations, and we had offered to supply any members. We had offered to supply any background that would be requested or helpful, or we thought would be helpful. So Workforce West Virginia decided to, as we understand, work with West Virginia University and work with Marshall University. But as far as our membership or our organization, we did not have any dealings with the product or the deliberation in the product.
You may not be clear of what transpired at those meetings also.
That is correct, yes, sir.
And maybe you can't answer this question. Do you know if there were representatives from the construction industry there, the labor construction industry?
To my knowledge, no.
They weren't involved?
No. To my knowledge, no.
Okay.
And I
So the
assume that's
committee
case.
and you were eliminated from the process, so we really don't know what happened with methodology, which I think may be something we need to look at. We had these studies, and I'm not sure what transpired or what happened, and here we are voting on this very, very important piece of legislation that affects a lot of families in West Virginia, and I'm not sure what occurred over the summer months with all that studies. That like I say, I saw articles in the paper, but you know, that's a reporter's viewpoint. I really don't know what occurred, so I'm somewhat in the dust here at Cloud. But thank you so much for being here and your comments.
Thank you, sir.
Thank you, Mr. Chairman.
Senator from Nicholas.
Thank you, Mr. Chairman. Mr. Hoyland, can I ask you to step back to the podium, please? I think I heard this. I just want to confirm this. In your presentation, we talked about the base wage rate. We also talked about the fringe that's paid on top of that.
Yep.
Looking at the fringe package, when a contractor that's working as a non-union contractor is working on a project, how is the wage paid to the employee as compared to a union? If you could talk a little more specificity about that. Is that paid as a taxable wage, or is it paid as?
It is, and thank you, Senator, to clarify, since they can't use that additional component to fund any other programs, it has to go to the employee benefit. We are one of a few states that has employee authorization over employers, so therefore they have discretion over how those additional funds, excuse me, are spent. So ultimately, they choose to have that kickback to them in the form of cash, which is an additional tax burden to both the employee and the employer.
Which becomes subject to FICA, Social Security, Medicare.
SUTA, FUTA, all those, yeah.
Exactly. And so therefore, that's an additional cost that the non-union contractors have to be subjected to, puts them at a disadvantage, an unfair advantage, as compared to a union contractor.
It is, it would be included in their bid.
Okay, let's talk about our public works projects, and if you could help me, and I'm going to make sure that I clarify on both sides.
Sure.
Both sides. All of the public work projects that we have within the state of West Virginia are prepared typically by design professionals. Is that correct?
It depends, but usually, yeah.
Okay. And typically, through the course of events, the design professional is involved not only in preparing the bidding package upon which a contractor would bid, but in addition to that, also provides traditionally services through the course of construction, which means that they typically are reviewing the quality of the workmanship, the progress, and reporting that back to the owner.
They're tasked with working closely with those who are working on the project, yes.
Okay. And there's nothing within the bid packages that stipulate that a union contractor versus a non-union contractor bidding on a particular project would have different safety objectives to meet. The same safety objectives are set out for all contractors, regardless of who would be participating in the
That's correct.
project.
Regardless of their labor affiliation, they fall under the same state statutes and requirements.
So therefore, we're not doing anything that would compromise worker safety on a job site.
No, and like I said, there's a requirement for all workers who work on state-funded projects to have OSHA 10 required training. So
Okay.
regardless, they would still have to meet those requirements.
Okay.
Our workers at ABC take those, and so do union workers.
Okay. I appreciate your presentation. Thank you. If I could ask leave of the chair to invite Mr. Klauser back as well. And just to confirm, Mr. Klauser, thank you.
Yes, sir.
Good to see you again.
Thank you.
And because you presented for one side and Mr. Hoylman presented for the other, I want to make sure that we have clarity from both sides that from the perspective that, you know, we have concurrence. You would agree with me that design professionals typically prepare the design packages within the state, and within that package is safety provisions that are available for all bidders on the project, regardless of their classification as to whether they are union or non-union.
Yes, sir.
Okay. And those same safety provisions apply to all.
Yes, sir.
There's no distinguishment or disparity between one or the other.
No.
Okay.
If you're a reputable contractor, you're going to provide a safe workforce for your people. Yes, sir.
Exactly. Okay, very good. With regard to the compensation packages that are stipulated within the bid packages, I know that you represent both union and non-union contractors as members of your organization.
We're about 50-50. Half our members are union, half work.
Okay. Am I understanding it correctly for those contractors who are non-union contractors who have to pay that fringe load, as we heard Mr. Hoylman speak a few minutes ago, those packages are traditionally, if they don't have a dedicated plan, are paid to the contractor's employees as cash benefits?
They would go, those benefits, as I understand them, Senator, go directly to the employee. Yes.
And that's the fringe benefit that's above the stipulated wage rate?
Correct.
Okay.
Yes, sir.
And so would you agree with me that in some respects that provides an unfair advantage for non-union contractors over union contractors? From the perspective that the non-union contractor has to pay that as a fringe cash load and has to pay the Social Security, Medicare, and everything benefit both, from the employer's perspective, which is an additional cost to his overhead.
I will tell you, Senator, I'm probably not a good person to ask on that, because I know within our association, we have some of our non-union members have plans already set up.
Okay.
That those go directly in, and then obviously that would not be part of a direct pay to the employee. If you were a firm that did not provide any benefits whatsoever, I assume your situation would be an accurate statement, but I know a lot of our members provide health insurance plans, pension plans, and so forth that are provided through the either the wage or the fringe benefit package to those employees.
Okay. Thank you. Appreciate it.
Thank you.
Senator from
I'll
Brooklyn.
yield back.
Thank you, Mr. Chairman. My question is for Steve White. Mr. White, the ACT Foundation. Thank you for being here, Mr. White. I recognize a comment here earlier on one of the folks saying that safety issues, both union, non-union, prevailing wage, and all those issues, all those workplace events going on, do you feel that safety, our worker safety programs, which are very important to me, do you feel that we will have or do have, or is there a variance of safety on projects, union, non-union, prevailing wage, not prevailing wage? The most important thing to me is safety. The wage, yes, mom and dad's going to have a tough living, but if dad's injured, they're going to have even a more difficult time making a living. So could you comment on your feelings with the trades and all the construction business that you have had over the past?
Sure. Steve White, Director of Affiliated Construction. First of all, we do not see this as a union, non-union issue. Prevailing wage is about local and about a level playing field. So we're not here saying union's better than non-union locally or that they can't do the job, what have you. The issue with safety, if you look at the data of the states that have a prevailing wage versus the states that don't, it's clear fatalities are much higher in states without a prevailing wage. Why? The reason is that when you cut wages severely and expect those workers to stay put and work for those wages, it does not happen. That is not the experience in other states. They will go to where the money is. They will leave to get the jobs, whether it's to Ohio, to Kentucky, to Pennsylvania, currently, Maryland, prevailing wage states. And in comes a new workforce without the training programs, without the experience, without the knowledge that is critical for a safe job site. So that's our understanding of where safety may go without the prevailing wage. The prevailing wage creates that level playing field. Union, non-union is not the issue. It protects and maintains the private market that's already in existence, applying it to those public jobs. And the experience, again, we can make predictions about West Virginia, but we simply need to look to other states that don't have it. And you have definitely more folks coming from outside the area who can use the cheap import labor and undercut the local markets. That's why it was put in place. That's the objective it tries to maintain and has done a good job. So I hope that answers the questions. I'm not saying that the local contractors don't, be it union or non-union, don't care about safety. It's just that that workforce tends to turn over and a younger, less experienced, less trained, and the training programs, frankly, are diminished as well. So those are the reasons, Senator.
And maybe I misstated that. Our states that have prevailing wage and states that don't have prevailing wage, do the contractors have the same safety standards on all state projects?
Well, we have, you know, it's hard to say. I don't know what other contractors have for standards. We have a minimum standard, as was alluded to here, that on public works you have to at least take the OSHA 10, a 10-hour OSHA course, legislation that you folks passed just recently. But there's many other aspects to safety. Safety is an everyday effort, and so to the extent that low dollar, because this is where the free market, you know, contradicts with the government market, to the extent that low dollar is what gets a project, everything else aside, it drives standards down. And whether there's cutting corners on safety or drug testing or training we think all those things will happen. And we see in other states where we believe it has happened. And that's what the statistics bear out. Fatalities in non-prevailing wage states are much higher. I've got a chart. I don't have the numbers in front of me, but perhaps as much as 50% higher fatalities in non-prevailing wage in construction than in prevailing wage states.
Living in the northern panhandle, Ohio plays a very important impact on labor in West Virginia. Is Ohio a prevailing wage state or a non-prevailing wage state?
It's a hybrid, if you will. For the most part, it is a prevailing wage state, with the exception of the schools K through 12 do not have prevailing wage, although on a county-by-county basis, they may so choose. Higher education, other government projects are prevailing wage in the state of Ohio.
Okay, thank you, Mr. White.
Thank you.
Senator from Greenbrier.
Thank you, Mr. Chairman. Steve? Sure. I'm an old history major, so I am curious, because you touched on it a little bit. First of all, why did we have a prevailing wage to begin with?
Well, again, it was in the 30s, so it was a little before my time.
Before mine, too, believe it or not.
Davis-Bacon is the federal law that we look to. There were some states, but Davis and Bacon, two Republicans, by the way, legislators, one from the House, one from the Senate, passed the bill in the 30s. And the concept was, of course, this was the Depression. Government spending was trying to stimulate the economy. People in communities thought, great, we're going to have a government project, and that's going to stimulate our economy. But they found out the low bid was undercutting the standards that they had established already, that private sector market they had. And instead of those jobs going to local companies, they were going to companies with low wages from outside the area. So Davis and Bacon were able to get the federal law passed that required pay the going rate, do a survey, pay the going rate for government projects, copy the private sector. And then many states followed with what are sometimes referred to as little Davis-Bacon or state prevailing wage laws, mostly in the 30s.
What's the history of and I know we're going to have to go soon, but what's the history of West Virginia? When did we start with our little Davis-Bacon?
Gosh, I want to say 33, but I could be off by a year or two.
And a lot of times you hear the discussion that the prevailing wage, and that's been alluded to here today, and you touched on the free market. Prevailing wage hurts free market. How is that?
Well, of course, we disagree. We think prevailing wage is meant to protect the free market, the private sector free market. Again, the concept, go survey what's going on in the market and apply that to government jobs, because government jobs are low bid jobs. And while, yes, there's design criteria established, you don't get points for your track record or for your reputation or your completion on time or your lack of change orders. Those are not things that are incorporated, which we might do in the private sector. You know, if you have a job in the private sector at your home, you don't necessarily take the low bid. And the low bidder can't say, I'm going to sue you if you don't take me. So the government sector is just different. And there's good reasons for the low bid. I'm not here to say it's not a good thing. So it's just different, and it's just not the same thing.
And in many ways, then, what you're saying, and I agree with you, but what you're saying is that this is an incentive for government projects, particularly state projects, to hire and contract with local companies to do jobs. And we're trying to do those incentives in agriculture and other ways, not affiliated what you do, but we're trying to do that in state procurement and other ways. So it's the same principle with labor, basically.
Right. You level the playing field. Competition from anywhere is open and accessible. That's very competitive industry. You're just leveling that playing field, and it's brought great results when we look at those per square foot costs. And I might add that we did a study, or we had an economist do a study who predicted it was up to $80 million in losses of wages and taxes. Mostly wages, but taxes, sales tax, payroll taxes, et cetera, with the repeal. So significant losses were predicted based on the repeal.
And Mr. Chair, again, I would say that is why we need a physical note. And I would move at this point that we lay this over until we have a physical note for our committee.
Is that a motion?
Yes, sir.
Motion before us is to lay this over,
Until we have a fiscal note.
until we have a fiscal note.
Yeah.
All,
Mr. Chairman, before the motion's made, I want to point out that under our Senate rules, I don't believe we can get a fiscal note for a House bill. The rules require that any fiscal note be attached and adopted by the originating House.
want to withdraw your motion?
I suppose there's no reason we make that motion if we can't do it then.
And if
Counsel, I'd like to thank you for stopping us, because
it's Senate Rule 15A.
okay.
Then, Mr. Chair, if may, I move that we commit this also for a second reference to the Finance Committee, recommend a Finance Committee commitment.
Counsel, we have problems with that one? I don't think there's an issue with that.
For a motion to
It's a motion to commit it to a second committee.
Oh, no. There's no
rule.
There's no rule prohibiting that.
Okay. So the motion before us is to commit it to a second committee.
Finance Committee.
To the Finance Committee. I don't believe it needs a second, does it?
He wants to discuss.
Yes. Discussion on the motion. Recognize the senator from behind.
Thank you, Mr. Chairman. I would just like to state that while I appreciate the gentleman's objective, as council's already told us, we're not able to request a fiscal note, so I'm not sure what the purpose of or what the Finance Committee would be capable of considering at that point. So for that reason, I would oppose the motion.
Further discussion? Hearing none, the motion is to commit it to have a second reference to finance. All those in favor will say aye.
And roll call, please.
All those opposed, say no. No. Opinion of the chair, the noes have it, and
Division.
the motion fails. Division. Okay. You want to, all in favor will raise their hands?
That's fine.
All those opposed? Again, appears the noes have it. The motion has failed. Other motions? I recognize the vice chair for a motion.
Thank you, Mr. Chairman. I move that House Bill 4005 be reported to the full Senate recommendation that do pass.
All those in favor will say
Discussion?
aye. Thank you. Roll call has been requested. Is the demand sustained? All those raise your hand if you're in favor of roll call. Oh. Yeah. I'm with you. And those opposed? Okay, so it will be roll call. The clerk will get ready and do a roll call on this for us. And this is for passage of House Bill 4005.
Senator Boso?
Aye.
Senator Facemeyer?
No.
Senator Ferns?
Aye.
Senator Gaunch? Senator Leonhardt? Senator Maynard? Senator Miller?
No.
Senator Mullins? Senator Palumbo? Senator Snyder? Senator Walters?
Aye.
Senator Williams? Senator Yost? Senator Blair?
Was that me?
Yes.
Aye. Total them and give the results, please.
Speak them?
Give
Yes.
the results.
8 yes, 6 no.
Okay, according to the results on the roll call, the motion's passed, or the bill is passed. The question is that the bill be reported to the full, wait a minute. The bill has passed and will go to the Senate for, with the recommendation that it do pass. Any other things to come before this committee? Sorry for porch baby.
Move we adjourn.
All those in favor say aye. Aye.